Good afternoon, students. Today is Thursday, 4 March 2021. This will be our third and final day on the New Mexico Supreme Court case, Morris versus Brandenburg, that was handed down in 2016. I'd like you to read the short excerpt from the Greek physician Hippocrates for our second lecture this week, which will probably be on Saturday, 2 days from now. I posted it the other day. It's very short. You may want to read the introductory material before you read the actual 2-page oath. And you can ignore the Greek version of the oath if you'd like, unless you happen to know Greek, which I do not. So there's an English translation of it that I would like you to read for the next lecture. Before we get back to the topic of the New Mexico Supreme Court case, I posted on Canvas a survey by the Gallup organization, and the title is Americans' Strong Support for Euthanasia Persists. Now, euthanasia can be thought of as mercy killing, and it's slightly different from what we're calling physician-assisted suicide. In euthanasia, one person causes the death of another person. In physician-assisted suicide, strictly speaking, the physician is not bringing about the death of the patient. The physician is assisting the patient in killing himself or herself. So euthanasia is a form of homicide, the killing of one human being by another. Physician-assisted suicide is a specific type of suicide where a given person kills him or herself. So I'm going to skip over the part of the Gallup survey that deals with euthanasia. If you look at about the third or fourth page, you'll see a diagram, and the title is Americans' Support for Doctor-Assisted Suicide. So this is just for informational purposes in case you're wondering how Americans view this topic. This chart shows over time changes in Americans' views of doctor-assisted suicide, and specifically, it's about the legality of it. So let's read very carefully what the survey asked respondents. It says, when a person has a disease that cannot be cured and is living in severe pain, do you think doctors should or should not be allowed by law to assist the patient to commit suicide if the patient requests it? So that's the exact question that respondents were asked. And you can see that over time, since going back to 1996, we've gotten anywhere from 51% saying that it should be allowed by law to 68%. And it fluctuates. It goes up and down over time. As recently as 2018, 65% of respondents said that doctor-assisted suicide should be allowed by law. Now, turn a couple of pages further in, and you'll see a different chart that has to do not with what the law should be, but about people's views about what is morally acceptable or unacceptable. So this time the question goes like this. Regardless of whether or not you think it should be legal for each one, please tell me whether you personally believe that in general it is morally acceptable or morally wrong. How about doctor-assisted suicide? And you can see that as of 2018, 54% of the respondents said it's morally acceptable. So 54% of respondents in 2018 said that physician or doctor-assisted suicide is morally acceptable. 65% of respondents said that the law should allow it. Well, that's interesting, isn't it? How do you explain the disparity between 54% who believe it's morally acceptable and 65% who believe the law should allow it? There must be some percentage of people who believe that, morally speaking, physician-assisted suicide is morally wrong, but who believe that the law should allow it. Interesting, isn't it? There are people some people, I don't know what percentage, who personally believe that it's morally wrong for a doctor to assist the suicide of someone, but who think that the law should allow it and not punish it. So it's an interesting set of data. I thought I'd post that for you just so you could get a feel for how this issue comes down in terms of the American public. Now, the other thing I want to go over before we get back to the case is my handout, which has been posted on Canvas. The title is Standards of Judicial Review. Now, I posted a handout on judicial review. Judicial review simply means that the court system, or some court, will review either a statute, which, remember, a statute is enacted into law by the legislature and signed by the executive. That's how it becomes law. And also, judicial review sometimes looks at executive orders. So judges are in the position of reviewing either legislation or executive action. And the job of the court is to determine whether the legislation or executive action is compatible with the Constitution of the state, if it's a state matter, or the federal government, if it's a federal matter. So the courts are charged with reviewing government action to determine whether it runs afoul of the Constitution. And when a court does that, when a court engages in judicial review, it employs different standards, right? And I've got 3 standards listed here. These are the 3 most often used. One of the standards is very strict. It's called strict scrutiny. And what that means is that the court will examine the legislation or the executive action very, very closely. And more often than not, the court will strike down the legislation or the executive action, okay, because it is looking very closely at it. The weakest standard of review is called rational basis review. You can see it's at the bottom of the list down here. Now, rational basis review means that the court is not looking at it so strictly, and the court, therefore, is more likely to uphold it and let it stand. There's also an intermediate standard of review. It's called intermediate review. You can see it there in the middle, and it's used only in certain cases, only in gender classifications, when a law or executive action classifies people by sex or gender. If it says, for example, that men can do something that women can't do, or that women can do something that men are not allowed to do, the court will apply intermediate review to it. At least that's been the court's practice. Some people think that the court should examine sex or gender classifications using strict scrutiny and would therefore be more likely to strike them down as unconstitutional. So the next thing we want to discuss is, when are these standards used? And then once we're done with that, we'll ask what the standard amounts to in practice. So if you look at the rightmost column over here on this side, I guess it is. No, over here. Okay, the third column from the left, you'll see that I've headed it with where applied. So the question is, when does a court use strict scrutiny? And the answer is in 2 different types of case. Whenever there's a fundamental right involved in the case, the court will apply strict scrutiny to it. Now, not every right is fundamental. Some rights we can think of as everyday run-of-the-mill rights. But some rights are more important than those. They're called fundamental rights. They're rights that are at the foundation of other rights. And we'll look at some examples in a moment. The other type of case where strict scrutiny is used is called suspect classifications. The law almost always classifies people. It says, for example, that residents of a certain city may or may not do something that other residents of other cities may do. The law classifies people by race, by sex, by ethnic origin or national origin. It classifies people by age. You can think of a lot of examples. You have to be a certain age to drink alcohol. You have to be a certain age to be eligible to vote. You have to be a certain age to drive an automobile. That's a classification. It divides people up into classes. It says that this class is able to do something that this other class is not able to do. Okay, so think of that as a legal classification. Some classifications are said to be suspect. And the reason they're suspect is because there is a long tradition of discrimination against people of certain classes. And so whenever the law makes a classification on the basis of one of these suspect classifications, the court will examine it strictly. It will apply strict scrutiny to it. And that means it's more likely to be struck down than it is to be upheld. Now, if you look at rational basis review in the third column, that standard is applied to all other legislative and executive action. If there's no fundamental right involved, and if there's no suspect classification, the court will fall back on regular old review, and it will ask the question, is there a rational basis for the law? If there is, the court will uphold the law. If there's not even a rational basis for it, the court will strike it down. Okay, so under rational basis review, more often than not, the court will uphold the government action. Under strict scrutiny, more often than not, the court will strike down the government action. So let's look at the footnotes. If you're wondering what kinds of rights are fundamental, here are some of them that the court has held are fundamental. The court has said that there's a fundamental right to interstate travel. Now, let's be careful with that. That doesn't mean you have a right to get in your car and go on vacation or something like that. What it has to do with is state eligibility requirements. Suppose a particular state held that in order to qualify for welfare payments in that state, you must be a resident for a whole year. Courts have struck down those kinds of requirements. They call them excessive. They say that people have a right to move from one state to another without being punished for it. Right? If most states say that you have to be a resident for only 30 days to be eligible for welfare, and one particular state says, no, you have to be a resident of this state for a year to get welfare payments, courts will strike that law down on the ground that it hinders people's ability to move around within the United States. So that has come to be known as the right to travel, the right to interstate travel. It's really a right to be mobile, to move from one state to another. The right to fairness in the criminal process has been held to be fundamental. When you're tried in a criminal court, you have a right to fundamentally fair procedures, and that's a fundamental right. You have fairness. You have a fundamental right to own firearms and possess firearms under the Second Amendment. That's been held to be fundamental, and so on. There are various rights, many of them incorporated in the Bill of Rights, that are held to be fundamental. And whenever a right is impinged upon by government action, the court will examine it or scrutinize it very strictly and is more likely to strike it down than to uphold it. Now, the suspect classifications, the ones that have been held to be subject to strict scrutiny, are as follows. Whenever a law distinguishes among people on the basis of their race, that's a suspect classification. And you can guess why. There's a long history in this country of racial discrimination on the basis of race. So the government is very vigilant in looking at such statutes or executive acts. Similarly, any law that distinguishes among people based on their national origin, if a law singled out people who are from Italy or Somalia or some other nation, China, for example, that legislation will be examined very strictly. If the law distinguishes among people on the basis of their legitimacy, now that's an old-fashioned term. Legitimacy means your parents were married to one another when you were born. You're said to be a legitimate offspring of that relationship. If your parents were not married when you were born, the old-fashioned word for that was illegitimacy. You were said to be an illegitimate child. And the law actually used words like bastard. You can still find law books where they have a section entitled bastardy, and that simply means children who are illegitimate. And the courts for some time now have looked at any law that distinguishes among people on the basis of legitimacy as being suspect. It's been used as a basis of discrimination, so the court will look at it very carefully. Will the court ever uphold a law like that? Possibly. Not likely, but it is possible. Or maybe I should say it's possible but not probable. So look at the middle column. I don't want to spend the whole period on this handout, but the middle column tells you what the state must establish in order to uphold the legislation or the executive action. And as you can guess, the state has a heavy burden to bear when we're dealing with a fundamental right or a suspect classification. So let's take a look. In the row headed strict scrutiny, which is the top row, you'll see in the middle column the following. What the state must establish. Number one, the state must establish that it has a compelling interest, and not only that, but that there's no less restrictive alternative. The state must show, in order to uphold the law, that there's no other way they could have accomplished their objectives without having a law like this. And that sometimes is hard to meet. Right? There's almost always another way to achieve the state's objectives other than classifying people by race or legitimacy. Okay, so the state has a heavy burden to bear. It's possible to bear that burden, but not likely. It's a difficult burden to bear. Think of a burden as something on your shoulder, a heavy weight. This standard, strict scrutiny, puts a very heavy weight on the state's shoulders. And the state may not be strong enough to hold up that weight. It may fall to the ground. That means the statute will be struck down. Okay, let's move down one row to the intermediate review, which is used in cases of sex or gender classifications. The state doesn't have to show a compelling interest. What it has to show is a substantial relationship to an important state interest. Okay, a substantial relationship to an important state interest. Not necessarily compelling, but still important. Go down to the third row and it gets even weaker. The burden the state bears here is quite light, a light burden, easy to bear up and carry. All the state has to show in a case such as rational basis review is that the statute in question bears a rational relationship to a legitimate state interest. Not an important state interest, the state doesn't have to show that, just a legitimate state interest. So the state has a lot of legitimate interest. The state has an interest in promoting the welfare of its citizens, the safety of its citizens. So the state has interests like those, and as long as the law has some rational connection to those interests, the law will be upheld. So really, rational basis rules out only laws that we might call insane or crazy, irrational, right? If there's a rational basis for the law, it will be upheld. That means that only an irrational law will be struck down. For example, what if the state had as its objective the safety of its citizens and required that they get to bed by 10 o'clock every night? The state may think that that has some bearing on safety. And I'm sure someone would challenge that law in court, and the court would look at that law and say, what's the rational connection between people going to bed before 10 and public safety? The connection, if there is one at all, is very tenuous. And the court is almost certain to strike a law like that down. But what if the law, in order to promote public safety, required that people drive only 30 miles per hour in a residential area? Clearly, a law like that bears a rational relationship to a legitimate state interest, which is public safety. So that law would be upheld. So the rational basis review really just rules out crazy, insane laws where there's no connection, no rational connection between the law and the state's objective or interest. Okay, we're going to come back to these standards shortly, because one of the big questions in this case involving assisted suicide is there a fundamental right? This case does not really have anything to do with suspect classifications, but it does have to do with whether there's a fundamental right to die. And that's a yes or no question, yes or no. Okay, this is yes, this is no. Well, that'll help me remember it. Here's yes. If the answer to that question is yes, if there is a fundamental right to die, then the court will apply strict scrutiny. That's the appropriate standard. And when the court applies strict scrutiny, it's far more likely to strike the law down than it is to uphold it. But what if the court determines that there's no fundamental right to die? That changes everything, doesn't it? If there's no fundamental right to die, then the court will go down to the bottom of the list. It will apply rational basis review, and that means that all the state has to show is that there's a legitimate interest, it has a legitimate interest, and that the law has a rational connection to that interest. So let me foreshadow where we're going with this. The Supreme Court of New Mexico eventually ruled that there is no fundamental right to die in New Mexico under the state's constitution. And the court therefore applied rational basis review. It then asked, is there a rational basis? And answered yes. Therefore, the law is upheld. Okay, so that's why I'm explaining these standards to you, because depending on which standard the court chooses to employ, the result almost certainly follows from it. So once the court determined that there's no fundamental right, the answer pretty much fell out from there. It was obvious. Okay, let's back up a little bit, because I've just been talking about the constitutional challenge to the New Mexico law. Let's go back and ask the first question. You know that New Mexico has a law on the books prohibiting assisting suicide. Let's review that law. I'm going to read it to you. It says, assisting suicide consists of deliberately aiding another in the taking of his own life. Period. That's the law that's under attack by Asia Riggs and her doctors, who are being represented by attorneys. Now, their first argument is that that law doesn't even apply to assisted suicide, or what they call aid in dying. By the way, I slipped up there. The plaintiffs in this case, Asia Riggs and her two doctors, they do not like calling what they do assisting suicide. They don't like the word suicide at all. They prefer to call it aid in dying. They say that physicians are aiding or assisting people in bringing about their own death. They don't like the word suicide because of its connotations. So let's take up the question now head on. Does this statute cover what the plaintiffs call aid in dying? By the way, I'm calling them the plaintiff. That's what they were originally called because they brought the lawsuit. By the time it reached the Supreme Court of New Mexico, they were called petitioners because they were petitioning the court for relief. And that's because they lost at the lower appellate level. So we can call them plaintiffs dash petitioners, or I'll sometimes just call them plaintiffs. I hope that's not confusing. The court almost always calls them petitioners or plaintiff-petitioners. So, does the statute that I just read to you cover their actions? That's a yes or no question. Suppose the answer is no. If the statute does not cover aid in dying, or what the plaintiffs call aid in dying, then the court will declare that they are immune from prosecution. Remember, when they filed their lawsuit, they asked for two things. Remember? They asked for a declaration by the court. Whoops. I shouldn't put that middle finger up. They asked for two things. Maybe I should. Sorry. I cracked myself up. The first thing they asked for was a declaratory judgment. So I better lower this one first. There we go. And what they wanted was a declaration by the court that their action in aiding people in dying does not run afoul of the criminal law of the state. And they also asked for an injunction, which enjoins prosecutors throughout the state from prosecuting people for violating that statute. So they asked for two things. If the Supreme Court rules that the statute does not cover their conduct, then presumably it would resolve this case simply by declaring that the statute doesn't apply and issuing an injunction against state officials so that they can't be prosecuted. Okay? So if the court rules that the statute does not apply, the case would be over. There would be no need to go on to the constitutional question at all. So, what if the court says, yes, the statute covers aid in dying? The next question is the statute constitutional? Yes or no? So I want you to realize that there's a kind of layered approach here. The first question is, does the statute apply to their conduct? Yes or no? And only if the answer to that question is yes, do we even get to the constitutional question. And suppose we do. The question is the statute compatible with the Constitution? Does the Constitution allow the state to have a law like this? And that's a yes or no question. The court ended up saying, yes, it does. The New Mexico Constitution does not prevent the state from prosecuting people for committing what's called assisting suicide. In other words, there's no right to die in the state under the Constitution. So let's begin with what's called statutory interpretation. In order to determine whether the statute covers the conduct that's in question here, the court has to interpret the statute, the words and the meaning of the statute. And the court brings to bear on page 8 a basic principle of statutory interpretation. And here it is. I'm going to quote. Our principal goal, our referring to the court, our principal goal in interpreting statutes is to give effect to the legislature's intent. Period. Now, where did that come from? The Supreme Court of New Mexico is quoting itself from a case that was decided 2 years earlier. The courts often do that. They use their own previously decided rulings to help them resolve the case that's now before them. And that's called precedent. When you resort to a previously decided case in your own jurisdiction, you are citing it as a precedent. And courts are supposed to follow precedent. They don't always do so. Right? There's a presumption in favor of following precedents, but it's a presumption that can be rebutted or overridden in particular cases. It's like the presumption of innocence. The presumption of innocence in a criminal case means that we're going to assume or presume that you're innocent until the prosecutor bears the burden of proving otherwise, that you're actually guilty. Well, what the New Mexico Supreme Court is saying is we are bound to follow our own precedents unless we have a very good reason not to. Okay? That's the doctrine of precedent. It has a fancy Latin name. I'm not going to test you on it, but let me tell you what it is. It's called stare decisis. Staredecissis. And it means let the thing stand. Let the decision stand. It means if a matter has been decided by this court in the past, then we should let it stand and use it to help us resolve this case, unless we have a very good reason to ignore it. And sometimes courts do. Sometimes courts overrule themselves. That happens from time to time. So notice what they're doing. They're rebutting the presumption that the previously decided case is good law. And they're saying it's no longer good law. We're overruling ourselves. So how did the Supreme Court resolve the issue? Remember, the purpose of statutory interpretation, as the court just explained, is to give effect to the legislative intent. Now, how does a court ascertain the intentions of the legislators or of the legislature? Remember, the legislature is made up of individuals who are called legislators. That's not how you pronounce it, but I'm trying to emphasize the ending of the word, ors. How do you ascertain intent? Well, one way to do it is to look at the plain meaning of the words that the legislature used. And that's what the court does in this case. The court looks at the statute. It says, is there any ambiguity in it? Is there any vagueness? Or is it clear? And does it clearly apply to the facts of this case? And the court ruled that it does. If you read the statute, it looks like it applies straightforwardly to what the plaintiffs call aid in dying. Let's once again read the statute. When I read this, ask yourself whether the plain meaning of the words cover the act of a physician prescribing a drug, a lethal dose of a drug, to a patient for the purpose of allowing the patient to use that drug to end his or her life. Okay, here's what it says. Assisting suicide consists of deliberately aiding another in the taking of his own life. And the court concluded that the plain words cover what the plaintiffs call aid in dying, right? There's no ambiguity. There's no vagueness. The meaning is clear and plain. And the court says, therefore, the statute involved in this case covers the act of aid in dying. Okay? Notice the statute doesn't say anything about prescribing a lethal dose of a drug, but the court assumes that that would fall under the term assisting suicide. If I prescribe a lethal dose of a drug for you, deliberately knowing that you may use it to end your life, I'm assisting you in killing yourself. There are a lot of ways to assist people, clearly. I can assist someone to commit suicide by lending him or her my gun. I can assist someone who, maybe someone is so weak that he or she cannot get the poison inside his or her mouth. If I lift the person's hand up and put the poison in the person's mouth, I'm assisting that person in killing him or herself. So the term assisting suicide encompasses a lot of different acts, one of which is prescribing a lethal dose of a drug. So at the end of this discussion, the court concludes on page 10, we therefore conclude that physician aid in dying falls within the proscription of the statute. That's on page 10. Now, before leaving this topic, I want to look at one interesting argument that the plaintiffs made through their attorneys. And this may surprise you, but they argued that the statute, which covers explicitly assisting suicide, requires a suicide. And they denied that aid in dying is suicide. They're saying that when a doctor prescribes a lethal dose of a drug to a patient who then takes it and dies, that that's not even a suicide, much less an assisted suicide. Now, how could they say that? It looks like a suicide. The patient took the drug and died. Right? That looks like it's suicide. Well, here's what let me get my copy of the case out. This is my copy of Morris versus Brandenburg. I hope you have your copy there handy. What did the plaintiffs argue? Take a look at page 9. I believe it's a footnote on page 9. Yes, footnote on page 9 of the opinion or ruling. Listen to this. One of the doctors, not one of the plaintiffs, but another doctor, Dr. Pollack, testified during the trial. Remember, there was initially a trial at which evidence was taken under oath. Dr. Pollack, well, let's just read this paragraph, and then we'll talk about it. Dr. David Pollack, a licensed psychiatrist who teaches at the Center for Ethics and Healthcare at Oregon Health and Science University, opined during trial that a death from aid in dying is not the same as a suicide. Interesting, why not? Suicide is typically brought on by a, quote, psychiatric condition, unquote, such as depression, and is characteristically an impulsive and solitary act. Accordingly, the family of a suicide victim will usually experience, quote, surprise, shock, and disbelief or anger, a whole set of emotional reactions reflecting a lack of connection between the person who committed suicide and those closest to that person. Okay? That's a typical case of suicide. You get a certain configuration of emotions, emotional reactions by loved ones, friends. It's usually done in isolation. There's a certain amount of shame associated with it. People are often ashamed to say, my loved one committed suicide. In fact, the very word committed, notice, we say committed suicide. Where else do we say committed? We say committed murder. We committed larceny. We use the word committed when we're talking about criminal behavior. Right? You committed a crime. When we say a person committed suicide, we're connoting or suggesting that there's something bad about it, maybe even criminal. So Dr. Pollack is trying to distance what the plaintiffs want to do from what people in the medical profession consider suicide. He's saying it's not suicide. That's what suicide is, what I just read to you. Here is what aid in dying is. So here we go. Back to the footnote. By contrast, Dr. Pollack testified, aid in dying is characterized by a deliberative process. It's not impulsive like the typical suicide. It's deliberate. That means it's thought through, often over a long period of time. People who are terminally ill and in great pain give a lot of thought to ending their lives. They don't necessarily act on their decision to kill themselves impulsively. It's thought out in many cases. According to Dr. Pollack, it almost always involves the person discussing it with his or her family and friends. There's a discussion, a dialogue, a give and take, whereas in a typical suicide, you might not get anything like that. Right? Suicide, when people learn of a suicide, they're often shocked and surprised because they had no forewarning. They had no idea that someone was suicidal. According to Dr. Pollack, patients choose aid in dying, quote, to alleviate symptoms, to spare others from the burden of watching them dwindle away or be a shell of their former self, or to feel like they are in control, have some autonomy and some control over the way they want to die, that they die. As a result, family members of patients who choose aid in dying and ultimately end their lives in that manner go through this process with the patient and are therefore, quote, more prepared for the person's death, unquote. I'm sorry, not unquote, and more at peace in relationship to it, unquote, as compared with the family of a suicide victim. So let's put this in perspective. The plaintiffs in this case are arguing with a straight face that what they're advocating, which they prefer to call aid in dying, is not suicide. And if there's no suicide, then there's no assisting suicide. And if there's no assisting suicide, then the statute, which prohibits assisting suicide, doesn't even apply to them. And if that's correct, then the court should give them declaratory relief and enjoin state officials from enforcing the law against them. Did the Supreme Court buy it or agree with it? No. Here's what the court said on page 9. Having looked at the argument, considered the argument, the court was not persuaded. I'll quote the court. Petitioners elicited detailed expert testimony from people like Dr. Pollack, explaining that the medical and psychological professions do not consider a death from aid in dying to be a suicide, and that the medical profession considers the underlying cause of death brought on by aid in dying to be the terminal illness itself. Okay, that's what the court says. The court disagreed that that aid in dying is not suicide. The Supreme Court of New Mexico ruled that the act of aid in dying is a form of assisting suicide. How did the court arrive at that conclusion? The court concluded that the proper meaning of the word suicide is not the meaning used in the medical field or the psychiatric field. Psychiatry, of course, is a branch of medicine. I didn't mean to imply that it wasn't. What the court is saying is the word suicide is a term of art in the law. And what the plaintiffs are advocating is that the meaning of that word in medicine be used by the court in the legal arena. And the court says, no, we have our own meaning of the word suicide in the law, and we don't have to accept your preferred meaning. In fact, here is the meaning of the word suicide in Black's Law Dictionary, which is the main law dictionary used by lawyers. Suicide, according to Black's Law Dictionary, is defined as self-destruction, semicolon, the deliberate termination of one's existence, unquote. That's what suicide is in the law. Notice, it makes no reference at all to whether the act was impulsive or deliberate. It makes no reference to the motive that drove the person to engage in self-destruction, right? The motive could be financial, so that your family gets insurance proceeds. The motive could be anger. Maybe you're trying to punish someone somehow by ending your life. Now, that may seem crazy, but I've heard of cases of adolescents killing themselves to punish their parents. You may have heard of cases like that. It's twisted thinking, perhaps, but that could be someone's motive. I'm going to punish my parents. I'm going to make their lives miserable forever by killing myself. Okay? That would be the motive, to punish someone. So suicide can have any number of different motives, according to the legal definition. The legal definition doesn't say anything at all about whether the suicide is justified or unjustified. That's not part of the definition. It may well be justifiable in the law, but that's not part of the meaning of the term. Okay? So the legal definition of suicide makes no reference to the motive. It makes no reference to whether the act was impulsive or thought out. It makes no reference to the context in which the death was brought about at all. So when the Supreme Court of the state of New Mexico applied the statute to the facts of this case, the court said, it looks like a suicide to us, according to the legal sense of that term. And the court therefore disagreed with the plaintiffs that the medical meaning of the word suicide should be applied in this case. So it was a very interesting argument, don't you think? And it failed. But that doesn't mean it was bad lawyering. The lawyers in this case made a very interesting argument. It simply wasn't persuasive to the court. It didn't end up winning. By the way, there's currently legislation in the state of New Mexico that would amend the assisting suicide law that we've been going over and discussing. And I want to read to you the changes in the law. Whether this will be enacted into law remains to be seen, but it's currently under consideration. I believe that it's been introduced in every session of the legislature for some years now. And you may think, well, why don't they give up on it? If it never gets enacted into law, aren't they just banging their head against a wall? Not necessarily, because things change, as you know. People's attitudes change. It's partly a process of education or awareness. You could try to educate people about why someone might want to end his or her life. We know that social mores can and do change over time. Who would have thought 10 or 20 years ago that the law would require that the Supreme Court of the United States would rule that every state in this country must allow 2 men or 2 women to marry each other? I mean, when I was a boy, or even 15 years ago, long after I was a boy, I would have laughed at the idea that the U.S. Supreme Court would rule in that way. And yet it happened. People's views of gay marriage or same-sex marriage have changed, as every poll will show you. And maybe people's views of aid in dying or assisted suicide, whatever you want to call it, maybe people's views will change. And this new legislation in New Mexico will finally get enacted into law. Maybe this year, maybe 2 years from now, maybe 8 years from now. I think the sponsors of the legislation will keep introducing it in every session of the legislature until they get it enacted. And it could be sometime or it could be fairly soon. In any event, let me read the language that's currently under consideration. And you'll notice that what it does is it adds an exception. It keeps the language of the law, and presumably there's a desire to ban assisted suicide in New Mexico. What the plaintiffs would like is for there to be an exception in the cases that they call aid in dying. So here's the language of the proposed statute. Assisting suicide. Okay, I'm gonna start over in a moment. When I put my finger up like this, that means there's some new language coming, okay? Assisting suicide consists of deliberately aiding another in the taking of the person's own life unless the person aiding another in the taking of the person's own life is a person acting in accordance with the provisions of the Elizabeth Whitefield End of Life Options Act. All of that verbiage after I raised my finger is new. It's being tacked on. There's been one other minor change made, you may have noticed. In the original law, it said taking of his own life. The new proposed legislation says taking of the person's own life. So it's removing a gender-specific pronoun, his, and replacing it with gender-neutral language, the persons. Okay, so I don't know that anybody would object to that, because obviously the word his always applied to women as well. So why not make it explicit rather than implicit? Now, I should explain, the rest of the legislation, which is called the Elizabeth Whitefield End of Life Options Act, it would be similar to the legislation in Oregon and other states that allow assisted suicide, physician-assisted suicide. So New Mexico is trying to emulate Oregon and the other 8 states in the country who have legislation allowing physician-assisted suicide. And as part of that legislative package, they are revising the assisted suicide law by making it clear that if the death in question was in compliance with the Elizabeth Whitefield part of it, then it would not constitute a crime under the assisting suicide statute. Okay, so the New Mexico Supreme Court has ruled, first of all, that the statute in question does apply to what the plaintiffs call aid in dying, and that means the question now becomes, is the statute compatible with the Constitution of the state of Mexico? Now, we're running a little bit low on time, and I know it's not a law class. I did provide to you my lecture notes, so I'm just going to give you the gist of the court's reasoning on the constitutional question. And when I draft exam questions for this part of the course, I will focus on mainly what I've covered up till now. And if I ask questions at all about the remainder of what I'm about to say today, they'll be very straightforward questions. I won't go into the nuances of legal analysis if you're worried about that. Notice on page 7 of my lecture notes, which I provided to you on Canvas, I have a diagram. It took me a while, but I eventually figured out the reasoning of the Supreme Court, and I tried to display that reasoning in the form of a flowchart. A flowchart is a chart that consists of a series of questions, typically with yes or no answers. And depending on how you answer the first question, you might get another question. Depending on how you answer that question, you might get another question. So a flowchart sometimes goes downward quite a ways. So let's work our way through the flowchart, and it'll give you the main idea of the court's reasoning. The first question the Supreme Court of New Mexico asks whenever someone challenges a law on grounds that it violates the Constitution of the state, the first question the courts will ask is this: does the state constitutional provision have a federal analog? In other words, does the language of the New Mexico Constitution look like the language of the United States Constitution? That's what the word analog means. Is the language similar to the language in the U.S. Constitution? Yes or no? Well, let's take the no answer first. You can see down below on my diagram, on the far right, you can see where I put no. And on the left, you can see where I put yes. So what if the answer is no? What if there's no federal analog? What if the language of the New Mexico Constitution doesn't appear anywhere even close in the U.S. Constitution? Well, obviously, as I say here, the court has to use the direct approach to interpreting its own state constitution. Right? If it has no similarities to the U.S. Constitution, then the U.S. Constitution has to just be put aside. And the Supreme Court, or whatever court it is in New Mexico, will interpret the language of the New Mexico Constitution using the usual techniques or methods. Okay, so let's set that column aside now. Let's go over to the column where there's a yes answer. So back to the question, does the state constitutional provision have a federal analog? What if the answer is yes? The question then becomes, next question, is the asserted right, in this case the right to die, protected under the U.S. Constitution? In other words, the New Mexico Supreme Court says whenever the language of our own state's constitution is similar to the language of the U.S. Constitution, we should look to what the federal courts have said and follow them. Okay? And so the question is the asserted right protected under the U.S. Constitution? That's a yes or no question. Suppose the answer is yes. What if, when the New Mexico court looks at the federal judiciary and it turns out that the right in question is protected by the U.S. Constitution, the New Mexico court obviously can't say no, it's not protected by the New Mexico Constitution, because remember what I told you the other day. No state constitution can protect individuals less than they are protected by the federal Constitution, the United States Constitution. A state can interpret its constitution as giving its citizens more rights or stronger rights than the U.S. Constitution gives them, but never fewer rights or weaker rights. So if the answer to that question is yes, the asserted right is protected by the U.S. Constitution, then the inquiry ends. The citizens of New Mexico would also have the right, because the federal courts have said all citizens of the United States have that right. So let's dispose of that yes answer now. We are now in the middle column with the no answer. What if the asserted right is not protected by the U.S. Constitution? In other words, what if the answer to that question is no? The next question is, does the New Mexico Constitution protect that right? So let's take up the first question. What did the U.S. Supreme Court say about whether there's a right to die? Because it has addressed that question. What it said is that there's no United States constitutional right to die. That was decided in the case of Glucksberg versus Washington in 1997. In that case, the U.S. Supreme Court, interpreting the U.S. Constitution, said there's no individual right to die for any citizen of the United States under the U.S. Constitution. So now the New Mexico Supreme Court has to follow Glucksberg, obviously, and the question then becomes, does the New Mexico Constitution confer a greater right than the U.S. Constitution does? That's a yes or a no question. And the Supreme Court of New Mexico, as you can see here, said no. The court said no. Our Constitution does not confer a greater right on citizens of New Mexico than they have under the U.S. Constitution. So in effect, the New Mexico Supreme Court simply followed Glucksberg. Glucksberg is the law of the land. It said there's no constitutional right to die under the U.S. Constitution. And the New Mexico Supreme Court said, and we interpret the New Mexico Constitution the same way. We see no reason to interpret the New Mexico Constitution as conferring a greater or stronger right to die than the U.S. Supreme Court found interpreting the U.S. Constitution. So if you turn the page of my lecture notes to page 8, I have a few more comments to make. The plaintiffs argued ingeniously that since Glucksberg had been decided almost 20 years earlier, there had been intervening cases decided by the U.S. Supreme Court that the plaintiffs thought might undercut Glucksberg. In other words, the plaintiffs were arguing that Glucksberg is no longer good law in the federal system. The New Mexico Supreme Court disagreed with that. The New Mexico Supreme Court said that Glucksberg has never been expressly overruled by the U.S. Supreme Court. It's still good law. Okay, so the court disposed of the plaintiff's argument that other cases, which you don't need to know about, had chipped away at Glucksberg. The New Mexico court looked at those cases and said, no, we believe that Glucksberg is still as good law as it was back in 1997. So the New Mexico court concluded that there's no fundamental right to die. Therefore, rational basis review applies. And that means that the question becomes, is there a rational basis for the law? And the court answered yes. The court upheld the assisting suicide law on the ground that there's a rational basis for it. The state has a legitimate interest in protecting and preventing people from killing themselves and preventing other people from helping them kill themselves, and that this law bears a rational relationship to that legitimate interest. And you can see all that, I'm taking that from this diagram that we went over earlier. look at the bottom row and you'll see where I got that language. So to end our discussion today, we're almost 1 hour in, I want to quote from page 27, which is near the end of this opinion. So please turn to page 27 in your copy of the opinion. You see it? I'm going to read part of a paragraph. I have a line drawn on the side. This is the New Mexico Supreme Court explaining why the assisting suicide statute in New Mexico bears a rational relationship to a legitimate state interest, okay, which is the weakest standard. Okay, we are persuaded that end-of-life decisions are inherently fraught or freighted with the potential for abuse and undue influence, as evidenced by the protections outlined in a couple of laws in New Mexico. You don't need to know what they are. And therefore, the government interests we have identified, similar to those in Glucksburg, are supported by a firm legal rationale. Applying this to petitioner's challenge, we conclude that there is a firm legal rationale behind, 1, the interest in protecting the integrity and ethics of the medical profession, 2, the interest in protecting vulnerable groups, including the poor, the elderly, and disabled persons, from abuse, neglect, and mistakes due to the real risk of subtle coercion and undue influence in end-of-life situations, or the desire of some to resort to physician aid in dying to spare their families the substantial financial burden of end-of-life healthcare costs. And 3, the legitimate concern that recognizing a right to physician aid in dying will lead to voluntary or involuntary euthanasia, because if it is a right, it must be made available to everyone, even when a duly appointed surrogate makes the decision, and even when the patient is unable to self-administer the life-ending medication. All right, sorry to read so much to you, but I wanted to get it out on the table so that I could discuss it for a few minutes. The court is citing 3 reasons that support this statute, and all of them are rationally related to the state's objectives or interests. And once again, the 3 are the interest in protecting the integrity and ethics of the medical profession. You can see why the state has an interest in that. Right? The medical profession is a very important institution in the state, and the law it has an interest in protecting its integrity. Now, the thought is that if doctors and other medical professionals are allowed to participate in suicide, or what the plaintiffs prefer to call aid in dying, the thought is that that will compromise the ethics and integrity of the medical professionals who are involved in that. Right? The court is saying that medical professionals should not be in the business of ending lives, even with the permission of the patient. The doctors and nurses should strive to keep people alive. And serious ethical questions would be raised if physicians and nurses were to become involved in ending life rather than preserving and promoting it. So to preserve the integrity of the medical profession, a law like this is needed. There's a rational connection between the law and this important state interest. Secondly, the court is worried that if physician-assisted suicide is allowed, it will result in certain vulnerable groups being exploited or taken advantage of. They name the poor, the elderly, and the disabled. The worry is that these groups of people in particular will end up having their lives taken away, perhaps because they've been discriminated against in the past, perhaps because they're less competent to make decisions for themselves, sometimes incompetent, and sometimes because they're more subject to being pressured or coerced. The court is worried, I think, that if physician-assisted suicide is allowed, people who are elderly might be pressured by family members to go see a doctor, get a lethal dose of a drug prescribed, take it home, and take it to end their lives. The worry is that they'll be pressured by family members to end their lives prematurely when they don't really want to end their lives. But everyone loves his or her family. Nobody wants to be a burden on his or her family. So if you believe, if you're elderly or disabled, or if you're elderly, poor, or disabled, and you believe that you have become a burden on your family, you may feel guilty about that. And that guilt may induce you to do something, namely end your life, that you would prefer not to do. Do we really want these vulnerable groups to be subjected to that kind of pressure? The court says we do not. And it's reasonable and rational for the state to worry about those vulnerable groups and just to have a blanket prohibition on assisting suicide, right? If assisting suicide is illegal across the board, then of course it's illegal for the poor, the elderly, and the disabled as well. And those are the ones we really want to protect. Now, I suppose an argument could be made that if this is the real rationale for the law should be more narrowly tailored. The law shouldn't speak in blanket terms. It shouldn't prohibit all assisting suicide, but only those cases involving a poor, elderly, or disabled person. Now, I don't know whether that argument was made. It's an interesting argument. If I were the attorney, I would have made it. I would have said that this statute is overbroad. It sweeps too far. It should be applied more narrowly to specific groups of people who are vulnerable to pressure and to coercion. So I don't know whether the lawyers made that argument, and if they didn't, why they didn't. It may have been strategic. Sometimes lawyers decide not to make arguments because they think that it will be a distraction, or they think the argument is too weak, or they're pretty sure it will not succeed, and therefore it simply distracts from the main argument. Okay, the third reason, you can tell my voice is almost gone, and I'm sorry if I appear to be yelling today. I don't mean to be, but when my voice is weak, I'm trying to project and make my voice as loud as it normally is, and maybe that leads me to seem to be yelling, or maybe I am yelling, I don't know. But I'm well intended. I'm trying to make sure you can understand what I'm saying. I guess if I were typing, it would be in all caps, right? Which people call yelling. Okay, the third rationale for the statute that the court discovers is concern for a slippery slope. The worry is that if assisting suicide is allowed, then euthanasia will be next. If we take one step on a slippery slope, we're going to be unable to stop because it's slippery, and we're going to slide all the way to the bottom. And do we want that? It's one thing to let a doctor assist someone in committing suicide, but what if that leads to homicide, where the doctor isn't even giving you pills that you take to end your life? The doctor just gives you a lethal injection at your request. Now, many people would say that's even worse. I mean, it's bad enough that doctors are prescribing lethal doses of drugs and then saying, good luck, as you walk out the door of the clinic. But it's another thing altogether for the doctor to say, come on in, let me give you an injection that will cause your death here and now in the clinic. For many people, there's a relevant difference between them. And they might say that however bad assisting suicide is for a physician, it's even worse, morally speaking, for the physician to be your killer. So the court is worried that there's a slippery slope at play, and allowing assisting suicide will inevitably lead to homicide or euthanasia. And certainly we don't want to go there, the court assumes. Okay, we're an hour and 10 minutes in. Sorry, I wanted to be thorough and cover the most important parts of the case. I hope you found it interesting. Maybe some of you even enjoyed it, despite the depressing topic. Again, I chose this case not because there's anything special about New Mexico, but because I wanted a case where there weren't too many different opinions, which is hard for students to wrap their minds around. In this case, there was only one opinion signed onto by all 5 justices. It's straightforward. The court explains the facts very well. I think they're understandable to my students, to you. So I chose it for that reason. All right, that's enough for today. I'll see you again Saturday. That's when I plan to lecture again. It's going to be on the Hippocratic Oath, which you may have heard of. So please read the short excerpt on Hippocrates that I posted. Read all of it. Some of it is information about Hippocrates and his time. And then there's the 2-page oath that is attributed to Hippocrates. This oath is quite famous. It's an oath that's still taken seriously by doctors today. And doctors strive to live up to it. All right, see you in a couple of days.